for this session. The title of the talk is The Future of Environmental Jurisprudence in India. We have Professor Geetanjoy Sahu, who is a professor and chairperson at Center for Climate Change and Sustainability Studies at TATA Institute of Social Science, that is TISS, Mumbai. He joined as a postdoctoral associate at the Center for Interdisciplinary Studies in Environmental and Development, Bangalore, upon receiving his PhD in Political Science from the Institute for Social and Economic Change, Bangalore. His broad areas of research and teaching include environmental jurisprudence, environmental regulation and policy, land and forest rights, and the political economy of public implementation. He is the author of the book Environmental Jurisprudence and the Supreme Court Litigation, Interpretation and Implementation, published by Orion Blackswan in 2014. Over to you, sir. Welcome.
Hello, good evening everyone. Can you hear me there? So thank you for this very generous introduction, and thanks to Professor Pankaj for inviting me and giving this opportunity to share the work which is an ongoing work. And first of all, also I would like to thank all of you coming at this time, because usually at this I don't see my students coming to seminar or session after 4:30, so they just disappear. But good to see all of you come here.
Don't give them ideas.
Okay. So before I begin, there are three caveats I want to set up. One is that I don't have legal background. I'm not a law student. By default, I started working on environmental jurisprudence. It was not by choice, as all of you would be also going through that phase. When I joined for my MPhil program at the Hyderabad Central University, it was my first exposure to any city outside my state. So I was there for almost 1 week in the hostel, just trying to understand how things are working. And by that time, everybody decided and choose their guide, and I was the only one left out to select a guide. I was a student of international politics, but when I approached the guide, the person who agreed to guide me said, only if you work on environmental movements, then only I'll guide you. Okay, so this is how I shifted from international politics to environmental politics, though I don't regret for that decision. This is what I have been experiencing in the last almost now 15 years as part of my work. The second caveat is, as I said, this is an ongoing work, and many times my colleagues ask why you keep working on environmental jurisprudence, and I don't mind to listen to them, because I see there is huge potential, especially as a non-legal scholar. There is a huge potential to engage with the jurisprudence question. There is the sociology of jurisprudence, there is politics of jurisprudence. So this is an ongoing work what I am going to present. And third caveat is, I am not going to talk about the impact of jurisprudence. This session is largely going to focus on the greenness of Indian jurisprudence. How green is the Indian Supreme Court? If at all it is green, what kind of greenness the Supreme Court brings in when it interprets any environmental litigation. So with these three caveats, I want to start the presentation. So broadly, these are the four components that I'm going to cover in the next 40 minutes. I'm sure you all are quite familiar with the concept of judicial activism, because not a single day passes today without Supreme Court or High Court judgment on important public policies, governance issues which are supposed to be addressed by the Parliament or by the Executive. So I'll make a brief presentation on that. Then we'll discuss what is unique about India's environmental jurisprudence, and that in two phases. One, the Supreme Court of India, which played a very important role and continues to play an important role when it comes to environmental matters. But in the year of 2010, the Government of India enacted a very progressive legislation, I would say, at least in letter and spirit. If you look at the Green Tribunal, this is one of the few tribunals you see in the developing countries which has been given special power to deal with environmental matters. In the last component, what are the lessons we can draw from these last it's a kind of 40 years of jurisprudence history. So you had environmental jurisprudence from 1980 to 2010 when Supreme Court was very active, and then post 2010 you are not required to go to High Court or Supreme Court, especially on certain environmental matters. You have to only go to the Green Tribunal. Now, to begin with the judicial activism part, let me tell you, very often you keep hearing about that the United States Supreme Court is very powerful. When you look at the power structure of United States of America Supreme Court. But when the Constituent Assembly met for discussion, framing the Constitution for almost 2 years, 11 months, one of the most contentious issues that was discussed during this period was what should be the nature and function of Indian judiciary. Broadly, you had two schools of thought in the Constituent Assembly. One school of thought was not in favor of making the Supreme Court of India as powerful as the Supreme Court of United States of America, because they were of the opinion, especially the radical socialists like your Govind Ballabh Pant, many other socialists believe that if you give Supreme Court supreme power to declare any law invalid passed by the Parliament if they are inconsistent with your constitutional philosophy, then we cannot implement our socialist policies like land reforms and many other policies and reforms. So that was one school of thought, not to give Supreme Court supreme power to interpret or declare any law invalid if they are not consistent with your other constitutional philosophy. The other school of thought, including Nehru and Ambedkar, strongly believe that today we are preparing the Constitution or framing the Constitution without any party politics or without any ideological perspective in mind. But in future, when there will be election, when there will be contestation between diverse political parties, there are possibilities where the majoritarian rule will bring certain policies and programs which might affect the rights of various other communities who may not have a voice in the political society. So to protect those minority groups, whether you talk about Dalits, tribals, Muslims, many other minority groups, you need to have a Supreme Court with the judicial review power, and that is how your Article 13 and Article 32 was inserted in your Constitution, where it says that any kind of inconsistency in enactment of law will be declared as invalid by the Supreme Court. So the judicial review power was inserted in Article 13. So this is how it began in the early phase of your judicial activism. But the concept of judicial activism, though it is popularized largely in the post-revolution period, it is not a unique phenomena in case of India, or not a unique phenomena in case of Asian countries. Across the globe today, you find there is global expansion of judicial power. So there is interesting literature which emphasizes that judicial activism is increasingly happening across the globe, whether you talk about Latin American countries, Asian countries or African countries. Increasingly we see there is an assertiveness among the courts and judicial authorities to declare any law or any policies which are inconsistent with your constitutional philosophy as invalid, or asking the enforcement authorities or executive authorities to discharge their constitutional duties. So this is how you see the global expansion of judicial power is happening, cutting across your continents, whether you talk about Asian or African or Latin American countries. In Indian context, what we are also witnessing, because of this assertiveness, now the judiciary, which is supposed to interpret the constitution, adjudicate the law, and that is what the political philosopher Montesquieu talked about, theory of separation of power. But the theory of separation of power today is no longer limited or relevant in the sense when you talk about the expansion and scope of judicial power. So the assigned role of the Indian judiciary was to interpret the law, but the court has assumed so many roles. For example, introducing CNG in Delhi. It was a policy decision, but the decision was taken by the Supreme Court, not by the government of Delhi or by the Minister of Environment and Forests or the Minister of Urban Transport. It was the Supreme Court who said the best fuel is CNG, introduced CNG as a policy, and that is how CNG came in the case of Delhi and subsequently many other states in the country. So the assigned role to assumed role, where it has assumed role of policy making and also policy implementing. For example, the Dhanu power plant in Maharashtra, where the committee has been appointed which is accountable to the court, which is consistently monitoring the process of the decision making that has been given by the Supreme Court. So in every arena of governance today you find there is intervention of judiciary and not a single public sphere or policy decision that is not within the purview of judiciary. So every case, that's what I say, like from IPL to BPL, like which team should be part of your IPL team, which household should come under the BPL category, and these are decisions not taken always by your parliament or by your executive authorities, rather they are taken by the judiciary. But when you look at the environmental matters, as I said, every public sphere, every public policy, right to health, right to livelihood, right to habitat, right to food, right to employment, in many of these cases you find the Supreme Court has contributed significantly. But when you look at the right to environment, and the environmental litigation stands out comparison to many other litigations in the country for the following reasons, because consistently the court has been part of the environmental jurisprudence process from 1980 to the current phase. Even after NGT was set up, the court continues to play an important role, and this increasing intervention is happening because there are several explanations. The one theoretical explanation why judicial activism is increasingly happening, especially in environmental matter, is the fragmented polity and political instability that we witness in our society. And when I say fragmented polity, it refers to those kind of political arrangements which are not stable. There are possibilities of coalition politics. There are possibilities where you see the coalition partners don't have the power to take away the power of the judiciary, and that was possible in 50s and 60s. In fact, if you look at the first 43 amendments in our constitution, including the first amendment that was made to take away the power of judiciary, because judiciary attempted to strike down your socialist legislations like land reforms legislations, because that was violating at that point in time your right to property, which was a fundamental right. And till your 43rd amendment, when Indira Gandhi was the Prime Minister during the emergency period, certain amendments were made to take away the power of the judiciary so that the Garibi Hatao programs can be implemented, some of the socialist policies can be implemented, because right to property was still part of your fundamental right. So that is how the fragmented polity played an important role to create space for judicial intervention. And if you look at the history of judicial intervention in the last 75 years, and this is what I wrote somewhere else, you had a confrontation phase. That was the first phase from 1947 to I would say 1977 till the emergency period. That was the confrontation phase, and the confrontation was between judiciary and the parliament to claim supremacy over the constitution. Okay, and then you had a consolidation phase after the Janata government came to power in 1978. From 78 to 89, that was the phase of consolidation, because the Supreme Court realized whenever we try to strike down a law which was passed by the parliament to achieve the socialist goals, our powers were taken away through amendment. And whenever we try to support the establishment, that happened during the emergency period in the most regressive judgment in the ADM Jabalpur case, when the Supreme Court said your fundamental rights are suspended, your right to life cannot be invoked. And during those days, public criticized the Supreme Court. So when they supported state, public criticized them, and when they supported the socialist, the right to property, the government criticized them. So in the post-emergency period, the court started reinventing its own will and emphasizing that we will focus more on executive actions, not the parliamentary actions. And that is how the consolidation phase, where they started bringing all these reforms, the prisoner reforms, your labor rights, the bonded labor, all these questions were dealt with. And it was during this phase, from 78 to 89, that was the consolidation phase, many of these important innovative methods were introduced by the Supreme Court, and one such is your public interest litigation came into picture during this period, which allowed third party representation in the court of law. And the third phase, which began from 89 onwards till your 2014 period, that was the coalition politics. And the theoretical explanation is whenever you have coalition politics, judiciary becomes more active. And look at some of these other countries. See, your neighboring countries, Pakistan Supreme Court is very powerful today. And I think the only Supreme Court in the world which has sent 5 prime ministers to jail. From Hussein Said to current Imran Khan, and Imran Khan is not going to be the last one, because when you have political instability, your Supreme Court becomes very powerful. Look at South African Supreme Court. Jacob Zuma, the president, was sent to jail. Look at Peru, Bolivia, any country where you have political instability, judiciary becomes very active, and that is exactly happened in India during that phase from 89 to 2014. That was the phase of your indiscriminate intervention by judiciary in every sphere of your public policy, including your environmental matters. And the fourth phase is the current phase, which I will be reflecting upon that, is very selective intervention, or what I call modified judicial activism, you could say, where there is selective intervention is happening in this current phase. But there is a close linkage between political stability and the nature of judicial activism that we see today. The second one is the kind of environmental justice groups that India witnessed in the post-emergency period. Everyone is aware of the Chipko movement, but Chipko movement didn't require to go to the court of law because the matter was resolved through a dialogue and discussion. But subsequently, there were several environmental groups, especially in the phase of post-emergency phase. Many environmental groups found it difficult to address environmental matters through electoral politics, because even today electoral politics doesn't recognize environmental issues as important political issues as part of the manifesto. You take the last election manifesto of 2019 or your regional political parties manifesto, nowhere you find environment or nuclear waste as important matters in their political manifesto. So environmental justice groups, when they fail that electoral politics is not addressing, including your Narmada Bachao Andolan, Tehri movement, many other movements that subsequently emerged, they went to Supreme Court, and that was the period because Supreme Court by that time already created the space for third party representation. But the most important contribution that happened and the reason for judicial activism is by the individual judges, and this is what I am going to talk about in the first phase, where you see the Supreme Court after this intervention phase, because that was the coalition politics where you had space for intervention, and there is a close linkage, as I said, because when you have political instability, it is very difficult to amend the constitution to take away the power of judiciary, because any power of judiciary to be curtailed, you need to have 2/3 majority in both houses of parliament, which many of these political parties didn't have from 1989 to 2014, and that allowed the judiciary to become more assertive. And it was during this period what I tried to do this analysis. This is the case Ratlam to Aravali, because Ratlam is a small town, now I think it's a big town in Madhya Pradesh, where the first environmental litigation in the country was filed in 1979. The judgment came in 1980, and the Aravali Hill, because by that time the National Green Tribunal was set up. So during this period, what was the philosophy and process of the Supreme Court vis-a-vis your environmental matters? So here, what we witness actually during this phase, there are two major contributions. One is the procedural side of environmental justice, and the second is the substantive environmental justice component. Okay. Now I think when you look at the innovative methods that the court introduced from 1979 to even the current phase, I think it is unparalleled when you compare with many other Supreme Courts of the world, including one of the very progressive land and environment court in Australia. Many courts are yet to create space for third party representation. Like today, anybody can go to the court, and this was possible because the Supreme Court of India introduced third party representation in environmental matters, and the architect for that was your Justice B.R. Krishna Iyer, who is very well known for his contribution and one of the best legal minds in the country when he was part of various cases during the emergency period, and subsequently he became the first judge also to introduce the concept of public interest environmental litigation in the country. And I remember when I was doing my PhD, he said he was greatly upset at that time because environmental matters were not considered by political parties, and there was also no NGO to take up these matters because NGOs were not allowed to represent third parties, and this is how the PIL was introduced in environmental matters, which was already there in other social and political matters. People used to go to court. So in this case, he says like environment cannot speak for itself, tigers cannot speak for themselves, so somebody needs to go to court to represent them. This is how the PIL began, and PIL contributed significantly to your environmental jurisprudence. And I think all of us are quite familiar with some of these environmental, public interest litigation actors like your Meda Patkar, who has filed several environmental litigations, especially if you look at there are so many interlocutory applications, petitions when it comes to Narmada Bachao Andolan. It continues even today. And the other person is your MC Mehta. I think the only person perhaps who has filed highest number of PILs in the country in Supreme Court in Green Tribunal, and MC Mehta continues to fight even today. In all these cases, if you look at MC Mehta or Meda Patkar's cases, these are the cases where they brought the concerns of affected people, who otherwise would not have gone to court because it is very difficult to hire a lawyer to approach the legal system. You need to file the petition, you need to also have the art of drafting the petition, and the expansion of your locus standi principle, that is your liberalization of your locus standi principle, allowed third party to go to the court. But what is more important, and the contribution of Indian judiciary is here, even though you are familiar with these figures, but the expansion of this locus standi principle has allowed many other farmers, tribals, the activists who are not known to public forums, but they have really played an important role, because the court said in most of these environmental matters, it is the subject which is more important, not the identity of the petitioner. You no need to be Meda Patkar or MC Mehta to go to court today. If the subject matter is about there is loss of biodiversity, loss of mangroves or any coastal erosion, then anybody can go to the court provided you have done the homework and you have drafted the petition in a way which invokes certain legislations which have been violated. So today you see, thanks to this kind of approach, what I see, there are many subalterns, in the sense, I'm sure you must have read Gayatri Chakravarti's work, who has written very excellent piece, Can the Subaltern Speak? And she argues that in many cases they cannot speak because they are very vulnerable. They come from a class where you don't have access to knowledge, power system, so somebody needs to represent them. And this is where you find people like Ramdas Kohli, who just studied to this 1680 fishing community members. So this is one of the landmark cases where you have the subalterns like Bimal Bhai, Bharat Patel, challenging the most powerful companies in Mundra port in Gujarat. So many of these activists, even students like Ridhima Pandey, who sort of filed also petition when there was landslide in Haridwar. So many of these petitioners who are not known to the public, but could benefit because of this procedural expansion of your locus standi principle. And this is not limited only to a particular regions today. Across the country, like central India, you go to northeast, many of these countries today, you third party representation who are not directly affected but have done excellent work in their field when it comes to representing third parties. Another important contribution here is also when you look at the procedural justice, application of your procedural flexibility principle, where the court says even if you have filed the petition, even if you have filed the petition only to address the concern for your city, for your forest degradation, but the Supreme Court says, like in this case of Almitra Patel or MC Mehta case, where MC Mehta filed a petition that there are tanneries in Kanpur which are polluting the Ganga river. The Supreme Court said, why only tanneries of Kanpur? Wherever you have tanneries, wherever you have industries which are polluting the river Ganga, this principle of compensation, precautionary principles are applicable. So in one direction, even though the prey here was limited to Kanpur city, but Supreme Court said no, all the tanneries should be closed down or they should pay a penalty. Same thing in the Gadavavan case, where even though he is no more, actually he passed away a long time back, but the court continues to hear this case where he filed a petition because there were illegal tree fellings happening in the Nilgiri Biosphere Reserve. But the court said why illegal tree felling is only a concern of Biosphere Reserve. Across the country, wherever the illegal fellings, you should stop. And then you have also the continuous mandamus where, So in the continuous mandamus, which is a legal term, which means the court continues to monitor the judgment after the order is given. Very often you see many judges are not interested to follow up their judgment. They say it is the job of the executive authority, why should we follow up the judgment? But there are also judges who believe what is the use of the judgment, landmark judgment, when they are not implemented. So in some cases you find again MC Mehta in this Gadavavan case, the court continues to monitor the scale and form of implementation and keeps giving direction to executive authorities. And then you have also, there are many cases where nobody goes to court, there are no petitioners, but the court initiates on its own intervention, like your Hindustan Times case or sorry, it is happening. In this Hindustan Times case, where there was a media coverage, but Justice Rajendra Babu picked up this issue and converted into a writ petition, because there was a newspaper coverage saying the Yamuna river is polluted and pollution control boards are not doing their duties. So this is how you have suo motu, you don't need to go to court or file a petition, but the individual judges can take suo motu decisions with reference to that. And then you have the green bench is another important contribution. So today you find every Friday there is a special bench, like you all are aware of, I think, constitutional bench, social justice bench. But you have a unique green bench. Every Friday this bench hears only environmental matters in the Supreme Court. And then you have also at the High Court level, there are several High Courts where you have also green benches, like your Gujarat High Court, West Bengal High Court, Maharashtra High Court. You have a dedicated green bench to hear your environmental matters. Now these are all procedural, environment side of your environmental justice, which are, as I said, unparalleled. And if you look at many other European countries, Supreme Court or the Australian Supreme Court, where you have similar environmental justice and jurisprudence processes, but these are innovative methods which in fact have been replicated in many other countries. But what is worrying factor for all of us is when it comes to the substantive side of your environmental justice, and this is where you see there are diverse perspectives here. And broadly, I see there are three distinctive approaches when it comes to Supreme Court's behavior towards environmental litigations. And these behavior of Supreme Court depends on who is the polluter. So depending on the polluter, the nature and scale of your jurisprudence process changes. And this is exactly happened in the last several years, where if there are industrial units as a polluter, so within industrial unit you have, say, ONGC and NTPC, but they are public sectors. But if you segregate only those litigations which are filed against your private industrial units, like say your industrial units like small scale leather industries or any pharmaceutical industries, so there is a one perspective of judiciary when it comes to litigations filed against private parties. The other is when the state is a polluter. When I say state is a polluter, so within state you have all these structures, microstructures, municipal bodies, panchayats, state governments and union governments. Here you have a different perspective. And then when, I don't know, one slide is missing anyway.
Should I run it from the laptop?
Okay, there is some problem actually. Now I use the PDF. So there are broadly there are three categories of litigation. When industrial units are polluters, you have a different perspective. when state is a polluter, you see a different interpretation by the court. And when community members could be your tribals, your slum dwellers, or your working class, anyone who is also part of the litigation, you see a different perspective. Now, let us discuss each one of these litigations. So when it comes to industrial pollution cases, irrespective of the location of the environmental problem, what you see, whether it is Kanpur tanneries or Vellore industrial areas or Bisri in Rajasthan or Vapi, Ankleshwar here in Gujarat and Maharashtra border areas, invariably you see there is a consistent approach by the judiciary, where it says that even if these industries are important for livelihood, for working class, they generate revenue, but we cannot allow the environment to be polluted. So most of these cases, there could be exceptional cases where the court takes a very defensive approach, but invariably if you take majority of the cases, the court emphasizes that the industries need to be closed down, or there should be pollution control mechanism. That is how it should be done. But in some of these also cases where the Supreme Court, in fact, this was the first case where the Supreme Court even had gone to the extent of demolishing these 4 buildings in Kerala, where more than 100 flats were constructed, but these flats were constructed by violating your coastal regulation zone. The CRZ notification was violated. The court said, no, we cannot hear this petition because they have not taken the clearance. The violation happened, so this allowed the buildings to be demolished. So these are the industrial pollution cases where you see how the court behaves. Now when it comes to community versus environment, when I say community, it's not a homogeneous community here, and here there are several litigations filed especially by NGOs, and these are NGOs which are again, you must have read about the bourgeois environmentalism literature, where many of these NGOs go to court and say tigers are important, city beautification programs are important, but the coast is here where there is no place for slum dwellers, or tribals are labeled as encroachers in many of these cases. And then also there are several judgments where the rickshaw pullers or the people who ride cycles, they are not allowed to enter to your city, like the city of Calcutta, where there are more than 100 lanes where cycles are not allowed, or if they are allowed, there are time limitations that you cannot go beyond this particular zone. So these are the challenges where you see when it comes to litigations filed against community and accusing them for polluting the environment. And the court has taken a very consistent perspective here, where the court says they are encroachers. And if you read the judgment, you could make out how court thinks about the common slum dwellers or your tribals. So this is the case which was represented by Prashant Bhushan, who is well known for his activism. But the court was not willing to listen, say no, they have encroached the land, and we have no space for, if you read the paragraph that I have highlighted here, when the court says you have no right to live in the city, and nobody said you have to come to Delhi, so you go wherever you want to go, but there is no space because you have encroached public land. Now this is how many of these cases, even the ongoing case in the Supreme Court against the forest rights, the claimants who filed the petition, because they have been also labeled as encroachers and their claims are yet to be settled. So you find there is a pattern in this approach of the Supreme Court. But what is disturbing when you look at the state as a polluter, because as I said, when it comes to community members, the slum dwellers or tribals or rickshaw pullers, the court says environment is important, you go wherever you want to go, you cannot protect your rights because you have encroached on public land. But if you look at state being a polluter, here you see there are two distinctive perspectives. One, when I say state, you have microstructures, say municipal bodies, panchayats, district administration, and then you have macrostructures like your union government or state government, or you have nowadays public-private partnership projects. In these cases, you have two different perspectives when it comes to litigations against state being a polluter. Now invariably, again, when microstructures are involved, like the municipal body is not collecting solid waste from your city, or not segregating, not disposing properly. So in all these cases, Even there are cases where Supreme Court says, okay, by 10 o'clock tomorrow I want to see the Bombay Commissioner in the court, or by 12 o'clock I want to see the forest officer in the court. See, in most of the cases in the microstructure, when they are accused as a polluter, the court has come down heavily against them. Okay, whether it is biomedical waste, whether it is your noise pollution, whether it is lake management, whether it is Thane Lake or Bombay, wherever, Powai Lake, the court has been very active in all these matters. It will give direction, it will follow it up. There will be a lot of media coverage, sometimes even they take so moto decisions in all these matters. Okay? So there is a kind of consistency when it comes to microstructures being a polluter. But if you look at the state initiated projects, when there are infrastructure, huge investment cases are involved, how the court behaves actually, irrespective of the landscape, irrespective of the political party ruling the state. And this is where you see again the huge investment cases, whether it is big dam, power plant, airport, bullet train, whatever types of massive projects that India is witnessing, you find here a very defensive approach from the court. It is not only defensive, and also very hands-up approach, where the court says these are projects which are important for your larger national interests. Now they started using the term national security, strategic importance, larger public interests, and these projects cannot be stopped. And here you see, for example, starting from the Narmada case to your current the Goa airport case, in all these cases, I am not going to highlight all those cases, but this is just an illustrative list of cases where you see there is a consistency when it comes to infrastructure, huge investment cases. Now, for example, in Narmada case, the court said, okay, the clearance was given in 1987, you are coming to court now in 1994, they have already invested huge money, you cannot stop the project, but we will take your consideration. For example, the resettlement and rehabilitation process will continue, but we cannot stop the project. Same thing, the recent case I am highlighting, the Goa International Airport case. Justice Chandrachud being the part of the bench. If you read the first paragraph, that was the interim order that was given, and which sounds very progressive, where he says you can't sort of, if you read, he says there can be no gambles with the environment. A heads I win, tails you lose. Approach is simply unacceptable, and unacceptable if you are to preserve the environment under the rule of law. That was the interim order. But when it comes to the final order, the same judge, Justice Chandrachud, takes a different perspective here, where it says, and he agrees to the Government of India's argument that this is an important airport. They are saying now zero carbon program, and so this should be allowed. And this is how this Goa airport has been approved by the Supreme Court. But in all these matters, whether it is Narmada or whether the latest one, the Goa International Airport, or the bullet train, Navi Mumbai airport, whichever case you take, you find consistently the court is saying these are policy matters, we cannot intervene. This is too late to intervene because they have already invested huge money, and these are public exchequer money, so we cannot stop. And these are also matters which involve science and technical details, and we don't have expertise, so we cannot intervene. And the last one is about larger public interest. But in addition to these factors, what the court also started nowadays using the principle of your locus standi, which was expanded, now started questioning many of these people going to court, rather justifying all these projects, whether it is Char Dham project, the bullet train. Whenever you read newspaper, you find all these statements. It's kind of copy paste the saying all are important for your national interest. So Char Dham, Bombay bullet train. Now the court says we will not stand in the way of projects of national importance. The central vista, the new parliament, all these cases, even it has gone to the extent of saying to the high courts, be careful while dealing with litigations related to infrastructure projects because they are important. And accordingly, the high court started following them. In many of the high courts now saying you can't stop these projects, even if there are violations, there are illegalities, they have justified them in the name of public interest. So in some other cases they say we will try to balance environment and development, but as you know, when you say balancing approach or neutral approach, that means you can't be neutral. Like when India says India is neutral between Russia and Ukraine, it's not neutral. The moment you say neutral, you are giving consent to the powerful communities in the society. That is exactly happening in these cases where the Supreme Court says we want to balance this environment and development. Very often the balance tilts in favor of the larger interest, excluding the communities who are dependent on forest or environment. So this is a more worrying factor, because in addition to those four reasons, policy matters, larger interests, technical details, too late, the court started now using this term fait accompli, which is again a legal term, where the court justifies the illegality. Okay? The court says already the project has started, we have invested so much money. So post facto clearance has become part and parcel of several environmental judgments, where it is an attempt to legalize the illegality, because under rule of law, when there is a crime, when somebody goes to the court, you are supposed to maintain the status quo till the decision is taken. But here they are saying, okay, already public exchequer money has been invested, so now start this project but pay the penalty or pay compensation amount. That is what they are saying. So these are some of the cases. I don't have time to discuss. This is the case where there was no environment clearance by this company, but the Supreme Court allowed this company to go ahead with post facto clearance, saying you pay the penalty but continue with your activity. Now, the last 7-8 minutes I want to talk about the NGT part, because I said this is how the Supreme Court's the noticeable trend you see when it comes to infrastructure, huge investment cases. But now the question is the NGT different from the Supreme Court? Because NGT was enacted with the hope that this will expedite the process of environmental justice, and there is a need for NGT because the Supreme Court said we are not experts, we don't have science and technical knowledge, so there should be a specialized body, and this specialized body was constituted in 2010, and when it was set up, many other countries, political leaders, even Supreme Court judges started looking at NGT, because it was lauded by many other activists, NGOs, friends who are working in the legal field, saying okay, there is now a legal forum where you can go to your regional branch, anybody can go to court, and here in addition to judges you have also experts. So scientists and engineers became part of the bench. So it started with the 10 judicial members, as the law says, you need to have 5 journal benches, and the condition, unlike your Supreme Court or High Court, there is no time limitation. There are several cases which are still going on for decades, but here the NGT Act says every litigation that comes to the NGT, it should be resolved within 6 months. So this is how the NGT started. A lot of enthusiasm, public euphoria, that this is how you have a bench with the multidisciplinary experts. But if you look at the last 10 years of NGT, what you see actually, as I said in the beginning, even some of us who started looking at NGT, supporting many of these decisions, judgments in the first phase of your NGT, especially when I say first phase, that was the phase when you had close to full-fledged bench in the NGT, consisting of the expert members, and one of the important experts from IIT Bombay, Dr. Ajay Deshpande, was one of the key experts in the NGT bench when it was very active from 2012 to 2017, and many other expert members were part of that bench in the first phase of your NGT. But when I look at the first phase, when I say first phase, because here you see there are certain trends and characteristics which can be labeled as a phase of ascendancy, which created space, and there was no departure from Supreme Court's philosophy of procedural justice. The NGT also continued PIL, third party representation. Even the NGT is more powerful if you look at the provisions, which says NGT is not bound by the Evidence Act of Government of India. It is not bound by Code of Civil Procedure. Rather, it can do justice and follow the principle of natural justice. So the high courts and the civil courts are bound by your Act of Evidence or your Code of Civil Procedure. So NGT can invite anyone, can change the procedure, can entertain any types of petition, it can go to the field also to decide the cases. So that is the kind of exclusive power that NGT was given, and NGT did that in many cases in the first phase, including the Ramdas Kohli case, where without a lawyer he argued and the case judgment came in his favor. But the next phase, and this is where I will stop by summarizing what is the problem actually. And this is the phase where the NGT chairperson, his tenure got over. Justice Sadendra Kumar was the chairperson, and for 7 months there was no chairperson in NGT. Many of the regional benches were almost not functioning, defunct, and people had no other option because NGT law says when you have NGT you cannot go to civil court. You have to only go to NGT. So earlier people had at least option to go to your civil court, which is right next to your town or your district. But now people cannot go to civil court because you have NGT. So justice, access to justice was denied when members were not appointed, and those members who were appointed, there were more bureaucrats and retired civil servants than having your expert members like Ajay Deshpande or many other scientists who joined in the first phase of your NGT. And now today you find arbitrarily the compensation awards are given. In fact, my analysis shows most of the NGT judgments are challenged in the Supreme Court, especially those judgments which are related to penalizing the companies, and companies don't agree the penalty amount because arbitrarily the award is decided, and they have followed this method of whatever your capital investment total turnover in the year, 5% of that you have to pay as a compensation. There is no other methodology that they are applying when it comes to compensation cases, and invariably the companies go to Supreme Court challenging the NGT decisions. And then you see the defensive approach continues here in the NGT when it comes to massive projects, but this is not limited only to state initiated projects. Today you find whether it is state initiated project, public-private partnership projects or projects by your private companies, you see very defensive approach. And this is also the phase, except those highlighted ones who come from environmental science and engineering background. All NGT members are, and it is clearly reflecting because in this phase you find the NGT has appointed more than 100 committees. So why there is a need to appoint a committee when you have experts? And now recently Supreme Court said you cannot delegate your power to committee members when this is a specialized body. And this is happening because you don't have members from science and technology background, and the member strength has also reduced, and there is no bench especially available in many of the regional benches. You can't have the second courtroom functioning because only you have one member, one judicial and one expert member. And because of this you find many of these cases in the NGT today, when it comes to the powerful actors, irrespective of whether it is a private company or public-private partnership, in most of these cases you find the ISA Foundation case where the Tamil Nadu Pollution Control Board had gone on record saying it violated the conditions because it was allowed to go for construction of some 10,000 square meter, but it constructed more than 1,20,000 square meter of buildings, and it should have been penalized. But somehow the Supreme Court said no, this is an education institute, it is not a yoga center. Even the Tamil Nadu Pollution Control Board said it is a yoga center, and yoga center can't be interpreted as an education institute, so they cannot be exempted from environmental clearance because there is a law. If you are constructing more than 20,000 square meter, you need to have environmental clearance. So without an environmental clearance it allowed, and the Supreme Court also justified. Even the central government filed affidavit saying it is an education institute, we cannot ask them to go for environmental clearance. Same thing for Art of Living case where the Art of Living cultural festival in Delhi was allowed, though they paid 5 crore, and then they challenged the Supreme Court saying we have not polluted the environment. And many of these cases in Kutch Mundra Port also you find where in fact in Mundra Port case the NGT was very progressive. NGT cancelled the clearance, whereas the Supreme Court said no, you cannot cancel the clearance because it is for larger public interest. So I want to, now the question is, has the judiciary abandoned environment for neoliberalism, what we are witnessing in the, I'll take last 3 minutes. So the last 3 decades if you look at, where we find that most of these cases, especially state initiated projects, there is a common thread. When it comes to community as a polluter, you find there is a common thread. But what we witness actually in this phase, especially in the last 3 decades, this is not the phase of Justice Krishna or P.N. Bhagavati questioning the state authorities or many of these illegalities that happen. In this phase, as I said, fait accompli principle has been invoked. many of these projects are justified even though the court recognizes that illegality happened. And this is not limited only to environmental matters. Look at the ED director, S.K. Misra, when the court says no, you cannot extend his tenure because he already completed his tenure. But the Supreme Court then finally says, okay, we will allow him now, his tenure is extended till 15 September. First you are saying it is illegal. Even the court had asked the Supreme Court why you are extending his tenure, don't you have competent officers to replace him? But his tenure is again extended in this case. So many of these cases you see the similar trend. So the exclusionary growth and development narrative is constantly sort of played out in the public discourse, where you have mainstream political parties, irrespective of their ideology. You see there is a consistency even within mainstream political party when it comes to the growth and development narrative, and supported by your media, then the dominant coalition forces, including your Picky and other things. And whether it is, as I say, irrespective of political parties, whether it was 2006 when P. Chidambaram was your finance minister, as you can read, says no, we need to have 2-digit growth rate. So anything comes in between, we'll keep set aside all of these activities or arguments, and that is what exactly when Bhupendra Yadav is saying the same thing. The green clearance is very fast now, and we don't have files pending. So when the political authorities, the leaders constantly trying and bringing this narrative to public discourse and domain, it has certain impact in the jurisprudence process, and that is exactly we are witnessing in the last 3 decades. Now what is the future actually? This is the last slide, I will stop here. I'm not saying that the future is uncertain actually, because if you look at all these last 3 decades history, there are also certain judgments which continue to motivate individuals, activists, NGOs to go to the court. Okay. Now, because there is a trend, does it mean we should stop going to the court, or are there alternatives? And I see the alternative, especially in the last few decades, there are many ways to look at the jurisprudence, but the constant approach to file litigation has been a kind of very counterproductive force for many of the environmental cases. So whether we should consider court as a last resort, I see there is importance and potential to explore many other avenues. The other avenues are not, I'm saying, think about the high court or the civil court. You can't go to civil court. But many other countries, especially when Australia started this mediation process, where you talk about bringing alternative dispute resolution mechanism. Even though it is very difficult because when you have diverse power structures, this is not a level playing field. There are certain cases where you could think about this alternative dispute resolution, especially when it comes to compensations, when it comes to restoration of the environment. There are cases. And then there is also need, because very often we see the engagement is more with civil society, NGOs, but the attempts are not being made when it comes to sensitizing the judges. Okay? Like for example, many of us who work or others who have been working, largely the focus is strengthening capacity building of NGOs, civil society groups, or to some extent limited to pollution control board members. But we have not reached out to the judges, and there is a forum in every state, judicial academy, and things have been different. In some cases, there are also judges like Madan Lakur or Justice Deepak Gupta or Justice S. Muralidhar, who played a very important role when you try to reach out to judges, especially sensitizing some of these important issues. And then of course you need to also have a dialogue, like unlike many other countries, especially in Germany, where there is a kind of space now for alignment of green and the red forces. In fact, they came to power from 1997 to 2004. But unfortunately, there is a kind of binary positions when it comes to Indian left and green movement leaders, and that is how you see those bourgeois going to court and justifying their petitions when it comes to relocation of slum dwellers or working class people, and they appealing for environmental justice. So I'll stop here. But as I said, the solution is not only with the court, because as you know, once you go to court, you don't have any other options. And so we need to think about some of these alternatives which are already very useful for many other countries. Sorry, I took 10 minutes extra. Thank you so much.
Am I audible at the back? Yeah. Yeah, thank you. Thanks a lot, Geetanjoy. This is an amazingly lucid account of the higher judiciary where environmental litigation is concerned, right? Going back to him talking about the Constituent Assembly and then coming to almost today. And I've personally also been involved in some litigation in Godavarman. Considering my grey hair, I've also been following these processes. So it has been so enlightening to see what may have happened when we've been involved. So thank you so much, Geetanjoy. It's a very nice elucidation of how we can make a very widespread, I think, account and presentation, but also not lose the interest and keep the interest going. And of course, IPL to BPL is. I saw many people smiling, and you must have seen half the audience was smiling. So thank you so much. And as always, only I will make one point, and maybe you can come to that later. Is this is still of the higher judiciary? When you and maybe you can address this point later, whether at the lower level of the judiciary, now with the NGT coming, you are saying that perhaps they are irrelevant. But how does this play out both between the dynamics of the lower judiciary and say the High Court and the Supreme Court, or is it, are we talking of two different universes? So I just park that question. If you have nothing else, you can take that, or you can respond to us later. We'd like the mic to go to students first to MTD 1, then MTD 2, then PhD.
Okay.
So MTD 1 is our first year masters. Arey there are some enterprising volunteers.
Hi sir, my name is Suraj. मैंने आपके स्लाइड्स में देखा कि बहुत सारे मतलब Sir, in many of your slides, I have seen like there are judgments which may not be true or may be, like Isha Foundation case. So how it happens? I want to know, like, what are the, is there anyone who interferes fear in the judgments or like something that?
Okay. I'll take couple of questions.
Okay, we take a couple of questions. Yeah, okay, thank you. Anybody else? I am in the back. Yeah, okay. Go for drop the mic. The best way to leave the camera.
Thank you. I actually had a very similar question to Pankaj sir as well, that you really mentioned how the levels of judiciary are different and what exactly is happening with the environmental movement. I also wanted to know your insights about, it's not just jurisprudence or also environmental policy in India, but also the interesting movement of nature's rights and how 2 rivers of India were given those rights and those were incidentally taken away from them as well. So just your insight on this and how again environmentalists or youth in activism sort of can take to smaller courts, to lower levels of jurisprudence. So just your insight on this.
Yeah, thank you. One more question we can take, and maybe Rohit, and then we can do the second round.
Hello sir. So my name is Rohit, second year MTech student here at TATA. So my question is regarding the contextual clarity between judicial activism and judicial overreach. Many a times you can see that judicial activism becomes judicial overreach, and it is under lot of what can I say? Lot of criticism. Like there is undermines the separation of power, as you have mentioned also. It also delays the justice to become into the public policy and public. So there are many cases in normal where we can find judicial overreach. So is there any example in case of environment where judicial overreach has been happened? That's my question.
Okay. I'll start with the last one, the judicial activism and judicial overreach. I think there is no disagreement. Yeah. So there is no disagreement about the need for judicial activism, because we see the other institutions, whether it is parliament or executive authorities or regulatory authorities, are not doing what they are supposed to do. Okay? So judicial activism is here to stay, but the scale and form of judicial activism needs to be debated. And one important question that you asked about the overreach part. There are many cases where you see there is overreaching of judicial activism, and one example that comes to my mind is your interlinking of river project. Okay, and interlinking of river project, nobody went to court actually. Nobody filed a PI. It was President Abdul Kalam's address to the nation on 26 January 2002 when he was the president, where he made a reference that there is a water crisis in the country And one way is to deal with the water crisis to think about the interlinking river project. Okay? And that speech was picked up by Justice B.N. Kripal, who was at that time judge of the Supreme Court, in one of the hearings of the Yamuna pollution case, where he said, now there is already president of the country who is a well-known scientist made a remark that one way is to address water crisis interlinking river projects. And that is how the interlinking river project began actually. It was not any state government or central government going and filing affidavit that you should have interlinking river. In fact, after the judgment, many of the states who feel that now water is going to be diverted from say Kerala to another state, or states which are likely to get water like Rajasthan, so they filed two different affidavits in the court. Like Rajasthan passed a resolution in the state assembly. This is a very progressive judgment because we will get water. Kerala, Tamil Nadu, many states passed affidavit saying no, this is violating federal principle. We have not been given a chance to speak about that. So there is a case like your interlinking river project, which is now completely sort of monitored, anchored by the Supreme Court. The same thing also the T.N. Gadavarman case. Even though many of the orders are very important and contributed to forest governance, but micromanagement of forests can't be done by the Supreme Court sitting in Delhi. Especially Northeast, if you look at the landscape, the history, the culture is different, and all of a sudden if you say all forests should be defined as at the meaning of dictionary, you have the forest. There are different ways to look at it. I think that is where we need to infer what types of activities are important, especially when it comes to environmental issues. Now the nature right, as you say, rightly pointed out, though everybody sort of celebrated also, I would say, when first the High Court said nature has a right like your right to life and you need to protect them. Though subsequently Supreme Court sort of gave a stay order. But yes, that this nature right or demand for nature right, especially the demand coming from those community members who are not necessarily active in public forum or consistently participating in a litigation process, but it has created space for demand, like the demand for nature, demand for forest, river rights. So definitely it has created that space for now new intervention dialogue. And I'm sure because other countries started following what India is doing about the right to nature. Okay, especially Australia Land and Environment Court has also started interpreting nature's right. So this is a very important initiative taken by many of those young citizens who went to court and now continue to argue that nature has a right, river has a right, even right to tiger. There are many people who go to court saying no, they cannot speak for themselves, so somebody needs to speak. So, but we need to wait and see how the Supreme Court sort of takes a position on that. And yes, see whatever I was talking about, all these cases, and being an academic, scholar, we need to be very careful when it comes to citation, judgment, and all these are based on the public materials which are already there. And if you go to indianqanun.com, you all are quite fortunate. In our time, we had to go to Supreme Court Library or High Court Library to find out the judgment. But you have now live law, bar and bench, indianqanun.com, where you get all the judgments, like whether it's Visa Foundation or whichever case you want to go and read. And these are facts actually. Tamil Nadu Pollution Control Board has filed an affidavit, and what I talked about is based on that judgment which is already there in public domain. The challenge is really, it's a big challenge because when NGT was conceptualized in 2009, when the bill was discussed in the parliament, and at that time Jairam Ramesh was the environmental minister, and it was one of those few legislations where you had intense debate in the parliament. And I would say perhaps the last environmental legislation which was debated intensively in the parliament, and there was a broad agreement that India will have a green tribunal, though a deliberate attempt was made not to have environmental court, rather we should have environmental tribunal, because if you have environmental court, then you need to give constitutional status and you cannot scrap these environmental courts. Whereas environmental tribunals, you cannot scrap them and you can sort of amend them at any time. But when environmental tribunals were made, and Jairam MS, while addressing the parliament, he assured the house, we are beginning only with 5 benches, but every state there will be a bench. That was the assurance given by the minister at that time, but somehow that didn't happen, and today we are left only with 5 benches, and lower courts cannot take environmental matters, especially those important legislations which are under the purview of the NGT. So it creates, a lot of sort of, I would say injustice, unjust process when it comes to people who are affected but cannot go to the civil court. Like just think about someone from Meghalaya, he or she has to come all the way to Kolkata to file a petition, or someone from say Gujarat, all the way he or she has to come to Pune. Okay, so as a result of which many of the environment, in fact in my work when I looked at the judgment, there are 867 judgments by the NGT. I am talking about only about the judgment. If you go by orders, there are some 30,000 orders by NGT. Okay. Now these are again very conservative figures given the scale and form of environmental conflicts, violations are happening, because many people are not able to go to court because there is no space today. Your civil court you cannot go. You go to high court says go to your bench, then you come to us. So this is a big challenge for I think many people who are engaged with environmental litigation.
Hello sir, I'm Omkar Bua, I'm a second year PhD student. So my question is related with basically public hearings, because in most of the projects, I'm referring to your comment that court says that already investment is there, the project is going on. But what I understand, for most of the projects where big infrastructure investment is there, the public hearings are compulsory. So how these are being taken either by a court or by a tribunal?
Thank you, sir, for that insightful talk. I am Aniket and I am doing a postdoctoral studies in IDP, climate studies. So my question is that, when there are popular movements against infrastructure projects, and particularly in the case of, for example, this oil refinery in Konkan, where there is a political backing from both sides at a time that is convenient. So the opposition is in power, if the BJP is in power, vice versa, they will back that movement against, and there is no scientific evidence where there is, evidence that there is a large-scale destruction to the environment. So how does the court then, how does it arbitrate, or how is it able to, resolve this matter? Because what has happened is, at least from my perspective, is that the refinery, if it is scrapped, it is a big loss to the budget. So
any NPD, we quickly jump to the PhD, any of the, wait, none of the NPD 1 and NPD 2 want to ask? Okay. Naina and then Hari, and then we come back to Geetanjoy.
Thank you, Professor. So my question is, so basically what I understood from the presentation is that you were trying to find certain patterns of how this judgments happens. And I just want to know that, so you said there are 3 kinds of approaches, industrial and state versus environment, and then community versus. So I'm sure there will be 3 kinds of specialized laws or 3 kinds of specialized approaches in these 3 matters, right? So you were talking about the results where how court decided. So I want to know how the approaches differ in each of these 3 cases. I mean, it's a very detailed thing, I understand, but certain common features of how you approach to a community question or an industrial question or a state question in micro and macro.
Give you one more question.
Yes.
Yeah, Hari. We come to you after the next round. Also introduce yourself.
My name is Hari Prasad. I am a PhD student at TATA. Thank you very much for the talk. I work on sanitation and keeping sanitation workers at the center of my research. And 2 of your points about legalizing the illegality and also post de facto clearance, penalty for violation. These are very important to my study as well, because we don't have a waste management system. And what we are happening, because the waste has to go somewhere,
Right.
and we know how the legality, illegality plays to each other. So thank you, and my question is about, first question is about how did the environmental verdict by the court happen before 1974 or 1975? Does they ever mentioned anything on environmental, the right to live or any other? Because the environmental concerns also came after 1970s and 80s, we know, and 1972 after the Stockholm Convention was the
projects which are scheduled in your EIA notification. It is mandatory. So whenever you go for highway, big dam, power plant, it is mandatory. So there are three possible outcomes when there is public hearing. One, you can approve the project. Second, you can reject the project. Third, you can ask for review of the EIA report. So the three possible outcomes. Now just think about, they rejected the project. Now once they reject, the Environmental Ministry has the discretion power to overrule their decision and clear the project. Okay? But then the law is also sort of very unique in this case. Even though the Supreme Court, the Environment Ministry overrules the decision, the public hearing that was done prior to the decision taken by the ministry, if they say no, if the project is approved, within 30 days you can go to the National Green Tribunal and challenge that decision of the ministry. And before tribunal it was Supreme Court. So your Vedanta judgment is one such case where in public hearing the tribals of Kalahandi and Raigad district, the 12 Gram Sabhas, they said no, but the ministry overruled the decision, approved the project, and then they went to the Supreme Court. Supreme Court said go back to the Gram Sabha and take their consent. And all 12 Gram Sabhas unanimously said no for this project. Okay? So there are several cases where public hearing is overruled, or the decision of public hearing is overruled, but people have asserted their rights because of the legal provision you have. You have Vedanta case, you have in Kinnaur district of Himachal Pradesh, people from Lipa village, they also rejected the hydropower plant project because they said no means no, that is the movement that is going on. So you have space even if your public hearing is rejected. And also nowadays public hearing is recorded because many cases they do forgery, take forgery signatures, they don't write the minutes. Now after the Vedanta case, Supreme Court said it should be video recorded. Whenever public hearing is happening, you should do the video recording of the meeting, and the minutes should be submitted to the committee. Now I think Aniket, your question about like definitely the movements, public protests, all these are increasingly happening when it comes to any type of infrastructure projects, and you have movements for and movement against, like your case is POSCO is a good example in Odisha. So few villages supported, other few villages opposed the project. Okay. But when the matter goes to the court, I think that is also related to your question about the role of science. Even though we have many public spirited citizens, like we talked about MC Mehta and many other Ramesh Agrawal, Bharat Patel, many other public spirited citizens, but unfortunately public spirited citizens don't get the support of public spirited scientists. So India needs more public spirited scientists who can bring their scientific reports, who can work with those NGOs, groups and organizations, and this is not happening. In fact, if you look at the United States of America or the Land and Environment Code of Australia, so there are interesting literature, role of science in the courtroom, where there are designated, like as you have in Indian Supreme Court, there is a bar association of lawyers. So you have bar association of scientists in the United States of America, where they are volunteering, and it is also part of their job. If they are working in university, it is also one of the mandates to contribute to this discourse and bring their evidence, and unfortunately that is not happening. And even though you have a genuine petition, the court looks into also the scientific evidences. In many cases petitioners fail to submit scientific reports because you cannot hire a scientist or go to private lab to do the test of whether it is water or air pollution. So this is where I think the challenge for public movements in the country, where we don't have many public scientists who can come forward, who can submit reports. And if you look at many of these other countries where you have bar association of scientists contributing to this process. Now, the related question that you asked about the legal, when you have, you asked the question that three distinctive approaches. See, there are many cases which are kind of open and shut case. So you have not taken clearance, started the building or started mining activity. So there the other factors are not important. So there is an illegal activity that needs to be penalized or industry needs to be closed down. So you have this kind of cases where irrespective of whichever law, whether it is environment law, forest law, wildlife law, if illegality has been done, the court should apply the rule of law and open and shut case. But there are other cases where you have multiple laws coming into picture, like the Forest Rights Act on the one hand, which says that recognition of forest dwelling communities' rights to be done, those who can claim that they were dependent or living on forest lands before 2005. Now then you have another law, Wildlife Protection Act of 1972, and there are many wildlife NGOs have gone to Supreme Court saying FRA will lead to disappearance of forests and tigers. Okay, and saying the FRA is constitutionally not valid because this is a land issue and central government cannot enact a law on land subject. So you have two different interpretations on the same subject. Now the case is pending before the Supreme Court. But one interesting thing that has happened over the last few years, because I am also part of the litigation filed by 9 academicians in the Supreme Court, where we argued, we presented our affidavit saying FRA is a very progressive legislation. It is an attempt to undo the historical injustice done to the community members. So you need to recognize them. In fact, there are clear evidences, and we have submitted those affidavits to the court. There are clear evidences wherever you have recognized Forest Rights Act, and the good examples are like your BRT Hills in Karnataka, your Similipal in Odisha, and then Udayanti Tiger Reserve in Chhattisgarh. The number of tiger has gone up actually. So saying that if you give forest rights, tigers will disappear, forest will be degraded, so there is no justification. Okay, so now that is what the court has to take a position. But one thing happened, as I said, the NGOs who went to court, first challenging the constitutional validity of the law, now they are one by one withdrawing that argument, saying no, the central government can make law on any subject. If that is the case, why did they support when Forest Conservation Act was enacted in 1980? Because these are the same NGOs who supported Forest Conservation Act, which is in place today. Okay, so when you have multiple laws, depending on like how these laws are interpreted by those multiple groups who go to court. Okay? But there is also convention, the law which is enacted can supersede the earlier laws enacted by the parliament or by the state legislature, but the court has to take a final decision if there are overlappings between these two laws. So like wildlife and FRA is a good example to see how it comes. Yeah, I addressed
Yeah, so we can maybe take one last question. Anybody? Oh, there are two last questions. Okay, great. Kamala, again. But brief question and brief answer.
okay.
Your answers have been brief, but.
So I am Prathamesh, I am first year PhD student. My question is about your comment about court being neoliberal and more pro-infrastructure judgment being passed since last few years. So when the Supreme Court itself does not have the expertise in such matter and it has to be dependent on other experts, but the research group or the experts may have conflicting affiliations and conflicting interests. So say in case of say RA car shed metro, so it was justified that over a period of time the felling of trees would be okay and it would be a carbon neutral metro. So in such cases, how difficult it is for the Supreme Court when there are conflicting conclusions from the research group itself. Say in case of Delhi case of CNG judgment as well, when there were conflicting conclusions from the research group itself, from the experts itself.
Yeah. My name is Yashashri and I am also a first year PhD student. It is just to follow up with the FCA amendment and the FRA, how it will override FRA in some sense, and how do we see that both these laws existing together? So, what is your comment on it? Yeah.
In fact, I'll answer the second one first. Many environmental groups today are writing, criticizing the Forest Conservation Act of 1980. But if you look at the history of the legislation, why FCA came into picture in 1980, it was not a very benevolent, intention when the law was introduced. It was in early 1970s. Many states, environmental groups, especially forest dwelling groups, started demanding regularization of their rights. And it started in Maharashtra, and there is a famous case, Pradeep Prabhu versus State of Maharashtra. And Pradeep Prabhu is one of those who drafted the FRA law. And Pradeep Prabhu, in that case, Supreme Court said you need to regularize the rights of forest dwelling communities who were living or dependent on forests. Now, sensing that, like Maharashtra, many other states are going to have similar legislation in future. So there was a lot of lobby to bring something so that the regularization will stop and central government will have more power on forests. Okay? So Forest Conservation Act came in 1980. Even though the argument was that to stop the indiscriminate diversion of forests, there was another story to this, or the hidden agenda was to stop regularization. And today, now the same FCA which was enacted in 1980 to stop diversion of forests, or not stop in the sense to take the consent of central government before you divert the forest. And after FCA you have so many legislation like FRA which says the pre-prior informed consent is mandatory, especially when it comes to protected areas. And then your Vedanta judgment came which says consent of the Gram Sabha is mandatory. The Environment Minister's own order, 9th August 2009 order, but when Jairam Ramesh was the minister. So all these orders legalize the consent of Gram Sabha is mandatory. Now FCA has exempted so many projects, and especially as I said, the linear projects, national importance projects. So this is going to create more litigations in the coming years, because how are you going to address when you have already a statutory law? In fact, if you look at northeast states which are going to play an important role in this case, because they have constitutional rights when it comes to forests, unlike in any other states. And then I think the
conflicting points of view.
Yeah. See, in every committee you will have people who come with a different ideological perspective. They have their own disciplinary baggage. And the CNG case that you talked about, so you had two NGOs. On the one hand, CSC in Delhi and TERI, another NGO in Delhi. So one supported the idea of having CNG as the best fuel. Another supported ultra low sulfur diesel as the best fuel. So when you have two conflicting reports, so court also does its own homework, and they found that the research work carried out by TERI group and other associations were supported by Navistar International company, which was world's largest truck manufacturing company, supporting the idea of ultra low sulfur diesel. Okay, and then they said, okay, we'll go for CNG till you have another alternative. So they do their homework, and so they are also human beings. They have so many other networks. They find out before the judgment. And in today's context, when there is media, there is a lot of information in public domain. So they do that now. Yeah.
Right. Let's give Geetanjoy a big round of applause. Thank you so much. I have two quick important announcements. This is a box of remaining dokla. So please eat and go. And maybe Geetanjoy can also offer you one. Please give it to me. That's point number one. Point number two, I just want to say that TATA is also initiating a new seminar series on wildlife in India. This is being done with the GIC DST Hub. We are starting this tomorrow with a film called All That Breathe. It's a beautiful film based in Delhi on the kites of Delhi, and a couple of brothers who are trying to rescue kites. The film is going to be screened in the IDC at 5:30 in the IDC auditorium tomorrow at 5:30, and we are going to have a talk by some of India's leading experts on wildlife every Wednesday in this room. So tomorrow is in IDC, but after that we will be in this. So please do attend. That is voluntary. It's not a Sitara permanent seminar, but please do come. Please also inform your communities in your hostels and all that, because it should be a very, very interesting series. So thank you very much, and I have one final request to Sharmishta. Can you please come ahead? Sharmishta is our colleague from HSS.